If you own a gun in America, everything you believed about your rights has just shifted. A federal appeals court issued a bombshell ruling this December that is reshaping gun laws nationwide. This decision includes 10 major changes, and several of them are truly shocking. These new rules grant you expanded freedoms while also creating legal pitfalls you might never expect. Make sure to hit subscribe right now because missing this information could cost you everything. Here are the 10 critical changes every gun owner must understand immediately. Law 1. Strict scrutiny as the mandatory standard. Law 1. Strict scrutiny as the mandatory standard. This first change is the core foundation that makes all the other reforms possible, and it completely overturns how gun laws have been handled in America. For decades, courts allowed the government to impose gun restrictions without proving that those rules were actually necessary. The December ruling confirms that every single gun law in the country must now survive what's known as strict scrutiny, the toughest legal test that exists. Whenever the government attempts to limit your gun rights, it now has to prove three things. First, it must show a genuinely compelling reason, not just a good intention. The burden of proof now fully rests on the government. This puts thousands of gun laws nationwide at serious risk of being struck down. But here is something even more important, something that directly impacts your wallet and that almost no one is talking about yet. Law 2. Law 2. Civil liability shield for lawful defense. Civil liability shield for lawful defense. If you ever need to use your firearm to defend yourself, this next change could prevent you from being financially destroyed. For years, even people who lawfully protected their own lives with their guns still got crushed in civil court. A man in Ohio shot a burglar breaking into his home at 2 a.m. He faced no criminal charges, yet the burglar's family sued him and won $400,000. A woman in California defended herself from an attacker in a parking lot, and the attacker sued her for $1.2 million, claiming excessive force. The December ruling creates complete immunity from civil lawsuits when you use a firearm in lawful self-defense. The criminal who attacked you cannot sue you for their injuries. Anyone who tries to sue must first prove that your actions were criminal before a civil case can even begin. But there's another change that determines whether the police can take your gun in the first place. Law 3. Law 3. Law Enforcement Accountability Standard. Law Enforcement Accountability Standard. Police officers who violate your gun rights are now facing consequences they never had to consider before. For decades, something known as qualified immunity shielded officers from personal responsibility, even when they clearly violated the law. That protection has now collapsed for Second Amendment violations. Under this December ruling, officers can no longer rely on qualified immunity when they break clearly established gun rights. If they seize your legally owned firearm without probable cause, they face personal liability. In Virginia last month, an officer confiscated a man's concealed carry handgun during a traffic stop, even though the man had a valid permit and properly disclosed it. That officer just lost a $300,000 personal judgment. This establishes real accountability that protects you from illegal police actions. But there is a specific type of location where the rules have now changed dramatically. Law 4. Sensitive places. Law 4. Sensitive place restrictions narrowed. The government's favorite tactic to ban guns almost everywhere has been effectively shut down. States like New York, New Jersey, and California came up with a workaround. They couldn't ban guns outright, so they labeled nearly every public location as a sensitive place. Some states had lists with more than 50 categories of prohibited areas. The December ruling eliminates that strategy entirely. The court created a strict two-part test defining what actually qualifies as a sensitive place. A courthouse with metal detectors and armed security qualifies. A school with screening and police officers qualifies. But a public park with nothing but a no-guns sign is no longer considered a sensitive place. Private businesses can still ask you to leave if they discover you are carrying, but they cannot have you arrested simply for being there. States must now cut their sensitive place lists by 80% or more. However, even getting permission to carry used to be a nightmare on its own. Law 5. Carry permits. Law 5. Carry permit processing timeline. The bureaucratic strategy of delaying your rights until you gave up is now over. For years, states with restrictive gun laws would accept your carry permit application and then ignore it. 3 months would pass, 6 months, a full year. New York had applications pending for an average of 18 months. The longer the delay, the more applicants eventually quit. Every state must now approve or deny your carry permit application within 60 days of submission. If the state does not respond within that window, your permit is automatically approved by default. States cannot request additional documents after you apply unless they identify a specific legal deficiency in writing. The 60-day clock starts the moment they receive your application and cannot be paused. If your application is denied, they must issue a detailed written explanation citing specific legal grounds. Several states have already reported approving more permits in the last 3 weeks than in the previous 6 months combined. But carrying legally only matters if you know what you're allowed to bring with you. Law 6, ammunition. Law 6, ammunition storage mandates struck down. The laws that made your firearm useless in an emergency have now been removed. Several states enacted ammunition storage rules that sounded reasonable but were purposely crafted to make guns ineffective for self-defense. Massachusetts required ammo to be stored in a locked container separate from the firearm. California required ammunition to be kept in a different room entirely. One county in Illinois required guns and ammunition to be stored on different floors of a home. Think about what that means in a real emergency. You grab your gun from the safe, then sprint to another room, unlock a separate box, load your weapon, and hope the intruder waits for you. The ruling states that ammunition storage laws that block immediate access violate the Second Amendment by making firearms useless for self-defense. You now have the right to store firearms and ammunition together in whatever way best fits your personal security needs. The government cannot dictate how ammunition is stored in your own home, but there's still the issue of whether states were tracking what you bought in the first place. Law 7. Law 7, Firearm Registry Prohibition Enforcement. Firearm Registry Prohibition Enforcement. The gun registry that was never supposed to exist has just been exposed and ordered to be dismantled. Federal law has banned a national gun registry since 1986. It is explicitly illegal for the government to maintain any system that connects specific firearms to specific individuals. But several states exploited a loophole. California's dealer record of sales system included data on every handgun purchase since 1996, 20 million records linking guns to owners. Hawaii required every firearm to be registered with police, including make, model, serial number, and owner information. The December ruling calls this out and orders these registries to be dismantled. Any state-level database that tracks individual gun owners or their specific firearms is illegal and violates federal law. These systems must be completely destroyed within 180 days. Every state maintaining these databases must send written confirmation to affected gun owners stating their data has been permanently deleted. Some states are already fighting this, but the court made clear that any refusal to comply will result in contempt charges and daily fines until the registries are eliminated. But there is another type of license that has been weaponized against gun owners. Law 8. Law 8, Federal Firearms License Reform. Federal Firearms License Reform. The ATF's go-to method for destroying gun businesses has now been declared legal. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives used FFL regulations as a tool to shut down dealers they disliked. They would conduct inspections searching for tiny mistakes in the massive amounts of paperwork required from gun dealers. A transposed serial number, a missing checkmark on a form from 3 years ago. A gun shop in Pennsylvania lost its license because the owner wrote 2022 instead of 2023 on a single document. A Texas dealer had his license revoked for using blue ink instead of black ink on transfer papers. The ruling states that the ATF may only revoke a federal firearms license if the holder commits an actual criminal violation, not for innocent administrative errors. The ATF must issue a written warning and provide reasonable time to correct honest mistakes before taking action. This restores fairness for small gun businesses and prevents the government from using regulatory technicalities as backdoor gun control. But protection at home means nothing if you can't travel with your firearm. Law 9, Concealed Carry. Law 9, Concealed Carry Reciprocity Expansion. Reciprocity expansion. Crossing state borders with your firearm has just become far simpler. For decades, concealed carry permits were tangled in a confusing patchwork of state-by-state recognition. You could have a valid permit in Georgia, but the moment you entered Florida, it meant nothing. Gun owners had to check complicated reciprocity maps before every trip, hoping the information was correct. People were arrested during traffic stops because they didn't realize their permit was invalid just 20 miles across the border. The December ruling establishes a nationwide baseline for permit recognition. If you possess a valid concealed carry permit from any state, at least 42 states are now required to honor it. Your Texas permit now works in New Mexico. The ruling states that no state may impose extra requirements on out-of-state permit holders. If your permit is valid in your home state, it is valid in 42 others, period. You can now travel across the country with your concealed firearm and remain legal.